I was 8 months pregnant, 4 days away from getting married, when my husband said, "Oh, we need to sign a prenup before we get married."
The court's not going to make an order in England that's going to be unfair.
He's stated he's not working and that he is unable to work due to medical reasons.
The only evidence that we are looking for will be proper medical evidence from a doctor that says because of this, he cannot work again, ever.
He used her credit card without her knowing. How can she now proceed to get the monies back off of him?
The situation that your daughter is in, it borders on fraud. In the family court, we would be saying, hey guys, and welcome back to the Legal Queen live show. I am your host, Tracy Maloney, also known as the Legal Queen on social media. I am a practicing family law solicitor and have been now for over 20 years. During that time, I've helped so many of you guys out with your divorce questions, your child custody problems, and love doing so. If you have a family law question that you think I could help you with, maybe you are making an application to the court, maybe you don't quite know what you're entitled to or what forms that you need to fill out, then please join me on the Legal Queen Discord. Come into the Legal Queen Lounge, pop your hand up, and I will invite you onto the stage to ask your question. Hopefully I'll be able to help you out. Now on with the show.
Hi, good afternoon. Thanks for
Hello.
taking my call.
That's okay.
I'm a litigant in person, so I'm now going to my final hearing.
Yes.
We had discussed in an interim a possible settlement, but it was all lies on my ex's behalf. So when I realized he was lying, I didn't sign the D81, but I pulled out before we submitted any D81s or signed for them. So we're now going to a final hearing. And since we've been getting divorced in 2023, my husband, my soon-to-be ex, has stated that he hasn't been working and that he is unable to work due to medical reasons.
Yes.
He's moved to Holland, so all the documentation and the medical reports that he submitted were all in all in Dutch, which I used Google Translate to put into English, and it literally says he's got carpal tunnel syndrome. But besides that point, I've now discovered that he actually has registered a business in Holland.
Yes.
And he's obviously stating to the court he's unable to work, and that's why he can't pay me out that much, because he's having to dip into his savings and stuff. Now, as I'm a litigant in person, I want to obviously submit the documentation to prove that he is working, but I also don't want his lawyers to have too much time to respond to it. Now, we've been told we have to submit our final statements 1 month before our final hearing, which we're obviously still waiting on the date. When is the best time, and how do I go about submitting my evidence that he's been lying all along?
I wouldn't be holding back. I wouldn't be holding back at all, because what you want to do is be as transparent as possible and afford them an opportunity to respond, rather than waiting until you're in court. Because the judge will say to you, well, if you had this information, why didn't you put it to them sooner? You know, maybe he wouldn't have wasted everyone's time. So I would do it as soon as you have it. Like, if you have it now, do it now. The other thing I would say is that lots of people, and family judges are familiar with this, but lots of people, when they're going through financial settlements, will then claim that their fixed term contract has come to an end, or that they've been made redundant, or that actually the stress and anxiety is crippling and they can't work anymore. But we look at the historic picture. If you've always been able to earn 40, 50, 60 grand, whatever it is per year, then the court will know that once these finances and the litigation is over, you'll go back to that position and the stress and anxiety will subside. So the only evidence that we are looking for will be proper medical evidence from a doctor or a surgeon that says because of this, he cannot work again, ever.
Yeah.
Carpal tunnel syndrome isn't going to cut it. That's not going to do it. But in addition,
I couldn't understand why the judges never asked for them to translate it into English. So they'd submitted this and, proof of why he can't work.
I'll tell you why, Kelly, because it's not judge's case, it's yours. So a
Okay.
lot of times people think, well, I'm just going to bring all my information to the judge and they're just going to tell us what to do. Absolutely not. If you want that document translating, if he wishes to rely on it, you have to be the one to say, hang on a minute, judge, I can't understand that. You know, I need this translating, or the court need this translating if he wishes to rely upon it. You know, the judge won't do your work for you. So that's a great question, actually, because that's a trap that a lot of people fall into. They just assume that court's going to take over and judge is going to take charge of everything. Absolutely not.
Yeah.
And right at the end, at the final hearing, the judge will make an order based on the evidence that's been in front of judge. But he won't be asking anybody to submit any further evidence or knocking evidence out that shouldn't have been submitted. So that's down to you. But I don't think he's got a strong case. A, the document's not in English. And B, it's probably not a document that says this prevents him from working. But C, you've got evidence to show he is working. So actually that would go towards his credibility.
Yeah.
In court.
Well, there's been quite a lot of lies backwards and forwards, especially on his part, in the fact that he's stated he's not working. He stated he doesn't have a bank account in overseas, which now has come about that he has.
Yeah.
Which again was a lie that I've queried right in the beginning, but nothing was ever forced upon. Now I've got proof. I've asked the courts to please have those documents, submitted, because obviously he's now said he has got a bank account in Holland.
Yeah.
My other question is, we have to submit the documents at the same time at 4 o'clock on a month before the court dates.
Yes.
But obviously I'm a litigant in person, so I can't post them onto the portal. So how does that then work if we have to submit them at the same time?
I think you would email them directly into court. You're going to email them to his solicitors, but you would then email them into the court if you don't have access to the portal. Or, depending on how nice his solicitor is, you could give it to them and say, would you upload this to the portal for me? If I was in your shoes, I'd probably email the court directly. And make sure that I bring a spare copy with me on the day of court in case the judge says, we didn't get yours. It will be in the bundle, actually. It will be included in the bundle as well. But yes, just email the court directly.
Yeah, because the courts have ruled that my husband's solicitors have to submit the bundle on both of our behalves.
But that's a different question to them uploading it on the portal for you.
Okay.
So the bundle is the final document that gets sent to court usually a week before, and it contains all of the evidence so that the judge just has it all in one place. But of course, if you want the court to have your statement a month before, which is what it's been ordered to do, then it might be that you email it to the court yourself as well.
Okay. Yeah, I do. I unfortunately do have a prenup because I got married in South Africa and I was very young and naive, and I signed a prenup. So there is a case of fighting the prenup because it has been said that it will be taken into account.
Okay.
However, they haven't said how much weight my prenup is going to hold. But he's been saying obviously he's not working and stuff. But now it's now basically proven that he's earning almost £75 an hour with his business.
Yeah.
And I'm on like £13 an hour. So obviously, will that give hopefully more weight to my case?
Depends, Kelly, what that prenup allows for. The reason that the judge has the power to ignore a prenup, although a lot of times these days they are guided by them more and more now, actually, which is good. And with, of course, Standish and Standish, that case being handed down last week, that helps us even more to ring-fence premarital assets and wealth. But it depends what your prenup says. I mean, the first issue for me, and the minute you said that, I think you and I have emailed, but the minute you, the first issue for me is it's out of jurisdiction, so the court doesn't have to be guided by it. If the court says it will, brilliant. But if it implements the prenup, then will the order that it's left with be fair and reasonable? So that's the question for the court, and that's why the English courts can set them aside.
Yeah, well, the English courts didn't set my prenup aside, and the prenup, I was 8 months pregnant, 4 days away from getting married, when my husband said, "Oh, we need to sign a prenup before we get married."
Yeah.
There was no financials passed between anyone. I didn't go see a solicitor by myself. We went to a mutual solicitor that he appointed. We literally went to the offices, signed the documents, and left.
Yeah.
And then received copies of the prenup afterwards. And I thought that we were only protecting the conversations that we had was that we were only protecting his business outside of our marriage.
Yes.
Meanwhile, we'd signed a prenup that protected any assets that was in his name during our marriage would remain his, and then anything
Yeah.
that was in my name would remain mine.
Yeah.
However,
So,
obviously, I never kept anything in my name because he had the bigger earning
yeah.
potential because I was a stay-at-home mom and all that kind of stuff. But now the laws in South Africa, where we signed the prenup, have changed, and the fact that they do look more
I shouldn't,
at the fuller picture and stuff like.
but it's the English courts that's deciding your divorce, right?
Yeah,
Yeah, so I wouldn't consume yourself with what South African law is saying because they're not dealing with this. The English courts are. So again, whilst the court hasn't made an order yet that the prenup isn't going to be submitted, they can't do that because obviously we're not at a final hearing yet. But when
yeah.
we get to
We had a separate hearing where
yeah, I
they were
know you would
deciding.
have had a pre-trial review, yeah, and it's been
Yeah, for the
left,
prenup, yeah.
yeah, it's been left in. But like I say, the court's not going to make an order in England that's going to be unfair.
Okay.
And if the prenup says everything that's in husband's name is ring fenced and all the assets in the marriage are in husband's name, chances are it's not going to stick to it
Okay.
because it wouldn't be fair. Okay.
Yeah. Yeah.
Brilliant.
Okay.
Thank you, Kelly.
Thank
Bye-bye.
you so much for your time. I really
That's
appreciate it.
okay.
Have a great day.
You too. Bye-bye. Sarah, how is it I can help?
Yeah, it's a bit of a long-winded question because I have to give you some context. I'm asking on behalf of a friend.
Okay.
He split up with his partner. They have 3 children. Probably about 3 years ago, he moved out of the house that they lived in that was in joint mortgage. He ended up getting a non-molestation order against her because of actions and things like that. He ended up not seeing his children for 9 months because she refused to let him see them altogether, just said that daddy doesn't love you, daddy doesn't want to see you,
Yeah.
just absolute vile.
Yeah.
He's been through court. He tried starting by self-representing to get access to the children and get a court order for sort of visitation, things like that.
Yeah.
That took 18 months. He ended up getting a barrister because she started getting the police involved with lies and other things as well. So it got really messy.
Yeah.
It took 5 court dates where he turned up to court where they had to adjourn it because she hadn't turned up for one reason or another.
Yeah.
He's pretty much almost bankrupt himself in order to do that. He has now won that. The judge actually spent 3 hours explaining why he was giving the father main custody, if for want of a better word. His problem now is he's currently renting. He does work. He's got a decent job with a decent salary. He works. He's renting. He's supporting the children, but he's skint on a day-to-day basis. He can afford to live, but literally day-to-day. Problem he's got is she still lives in the home. They were never married, but the mortgage is in both of their names.
Yeah.
She's not paying the mortgage and keeps letting it go into default, and then DWP keep paying off the arrears every sort of 6 to 8 months. But that's affecting his credit score, so he's never going to be able to get a mortgage. He's struggling to find rentals that'll accept him because of that credit history now. How can he go about removing his name off that house? He doesn't even care about if there's any equity to take that out of it. But he now has the children. She has one other child with another person since they split up. But he's been told that he either has to wait for it to be repossessed, which is obviously going to ruin his credit score even further, or he's going to have to pay for a solicitor to be able to go back to court to get her to either sell the property or buy him out, because the mortgage company won't let him remove his name off it because she doesn't work and can't afford to pay the mortgage.
Sure.
Which is
So
obvious because she hasn't been.
I get it. So I think that the aim here is for him to get back control, because ultimately his credit score is being affected by somebody else. Again, it's a problem that we have all of the time. She cannot afford to stay there and he cannot afford to support 2 houses. Okay. That's fact. No. So that is fact. If she is not willing to have the property placed on the market for sale, because that's the answer, if she is in receipt of benefits, then she will be afforded a council property. he will then be able to support himself and not have his credit rating impacted. If she won't agree to put the property on the market for sale, then he has to go to court and get an order for sale. Okay, but that doesn't mean that he's got to instruct a solicitor. A lot of the clients that I have on my books aren't engaging me to do everything. You know, they will touch base with me once every 2 to 3 months, because they just need me to tell them what to do next and to give them templates of forms or statements or whatever it might be. So don't allow him to think that I can't go and get an order for sale because I can't afford to have the solicitors do that. He doesn't need the solicitors. He can do it himself. In fact, he's going to have to do it himself because he can't afford to pay them. Either that, or he sits back and allows his credit rating to get even worse. So taking back control is his main objective. And he does that by getting an order for sale. Were they married?
No, they weren't married.
Okay.
It was a toxic relationship from start to finish. Police had been involved. She had him arrested about 6 years ago.
I get it. I get it. Yeah.
It just got horrific.
Yeah, I absolutely get it. I mean, a lot of what you've told me isn't relevant for the order for sale. Because it's, you know, you bring a lot of emotion into it. It will be dealt with under Talata, which is the Trust of Land Act, because they weren't married. But all he's asking for is that the house is sold because, you know, he's entitled to his equity. Is it owned jointly? Have both their names on it?
Yeah, both names.
So, you know, the law's very clear when you're not married. She gets her 50%, he gets his 50%, and off they go. She'll be given the option. Do you want to buy him out or not? No, I can't afford to. Well, fine, let's get it sold then. Because he is legally entitled to his equity. Now, she could then argue, well, hang on a minute, I've got children here, they're his children, and I need their house. Yes, but you can't afford to stay there, and he can't afford...
He now has majority of... They only see the mother every other weekend and on Tuesdays now, so he now has the children the majority of the time.
Okay, so that's going to strengthen his argument again in terms of asking for an order for sale, but that's what he needs to do. And if he wants to just have a one-off advice with us as to how he does that, then let him, you know, by all means, he can call the office and sort that out. It's a little bit more complicated when you're not married. If they were married, I'd be able to say do the Form A, but when you're not married, it's a little bit more complicated. So I would definitely say to him, look, consider just having a one-off advice so we can tell you what forms to do and the statement and all the rest of it, and we can provide him with some helpful templates. But that's all. That's all he'd need from us, really. And then off he goes and does it himself.
Are there any costs involved if you're just submitting the form to court and just trying to get that order for sale? Are there any costs involved in that?
There will be costs involved, and that's directly influenced by the equity that's in the property. And the reason that I'm pushing and saying he must have a consultation with us is because he wants to make sure what he's asking for is going to succeed, because there could also be other costs involved. You know, if he loses his case. But the thing is, he is well within his rights to get that control back.
Yeah.
Lovely. All right, Sarah, thanks for that question.
Thank you.
Brilliant. Bye-bye.
Okay, quick question. You may be able to help, you may not. Okay, my now daughter-in-law is paying off her credit card debt.
Yes.
Where her ex-husband ran up the debt without her knowing. He hid all the bills when it came through, went through with the divorce amicably. She's now entered into an IVA, but how can she now proceed to get the monies back off of him?
So get what monies back? Sorry, Dave, just say that first bit to me again. What monies is she trying to get back?
Okay, he used her credit card without her knowing.
Yes.
I know it's her name that's on it and she's responsible, etc.
Yes.
He's gone here, there and everywhere, spent loads of money.
Yeah.
Hid all the bills when they came through.
I see. Sorry,
divorced.
Yeah.
How she's now entered into an IVA.
Yes.
She's paying X amount per month and it's killing her financially. Is there anything she do to claim anything back off of him?
As when they got their divorce, Dave, did they get their financial order as part of that?
Don't know.
Okay, so that's the first question you want to ask her. The divorce is always split into two parts. We're going to be getting the actual divorce, which means that the marriage comes to an end. All that means, though, is that we can legally remarry again. The second part of it is a financial order. The financial order is the most important part in my view because it severs financial ties between the parties. When we are giving advice to a client about getting a financial order, we will ask the question around debts and whether or not these debts are matrimonial. Now, the situation that your daughter is in, it borders on fraud, okay, because she wasn't aware that her credit card was being used. And I would be suggesting that she have a discreet conversation with a criminal lawyer about that. However, I'm not a criminal lawyer, so I can't take that line of questioning any further. In the family court, we would be saying, absolutely, this is matrimonial debt. And therefore, he shares with me the responsibility of paying that debt. What I would then want to do is look at the assets, if there are any, from the marriage. And if there aren't any, then potentially his income to see if he can help her pay down this debt. So if she has... Go on.
Sorry. There are no assets.
Right.
His income is hidden. He's self-employed.
Okay. She still needs to get some advice, though. Because I think even if she were to just have a quick 30 minutes or an hour, there might be something that comes out in that consultation that makes me think, oh, okay, we've got some leverage there. Okay, it's worth asking the question. If she says to you, Dad, I've already got my financial order, then there is no point me speaking to her, unfortunately, because the financial order, it's done and dusted. But chances are she might not have got one because all this would have come out in the wash if she had have got one. So I'm hoping she says to you, no, I didn't get one of them, Dad, in which case I'd say, look, let's arrange a quick chat with me and see if there's some way that we can help her. If nothing else, than to just get, a few £1,000 to help her with this debt.
Absolutely brilliant. Thank
you
very
right,
much for your
I'll
guidance.
leave that with you.
You're doing a fabulous job.
Thank you for that, Dave. I'll speak to you soon. Bye-bye.
Bye-bye.
Dave, let me come to you. Let me just take you off mute. There we go. Dave, how can I help?
My goodness, all these buttons, I'm getting confused. Sorry, no, I think one of your colleagues is it Zoe?
Yes.
She's replied to me.
Lovely.
She has remarried, so therefore she cannot obtain a financial order, can she?
Oh, no, she can't, Dave. Is this a question about your daughter? No. If she's remarried, yes. No, she can't go back. That is such a shame.
Okay, no problem.
All right.
Problem solved. Thank you very much. Keep up the good work.
Thank you. Will do. Bye.
Hi.
Hello. Hello.
Okay. I need some advice. So I've got my I live with my two girls in our family home. They're 10 and she's about to start GCSEs next year. And my ex has gone off out of the house, and he just keeps telling me it's not my home, it's going to get sold. There needs a bit of renovation still needs to be done, like a utility room and a bathroom. And the joint savings have been taken apparently for that.
Yeah.
So that's gone down to zero. And he sort of said, obviously you're not going to touch my pension. He's got a very large police pension and earns double what I earn. And I do have a full-time job, and I'd like to try and stay here. And I don't really want the renovations done.
Yeah.
Because I think it's better for me if the house is worth not loads, because I want to be able to stay here.
Yeah.
And I don't know if I've got a chance. I don't know, I don't know how it's worked out.
All right. So what I'm going to say to you, Olive, is that you've got to speak to me. You've got to have an appointment, because that's the only way, really, by asking you a few questions and getting the answers to them, which I can't ask you on this forum. I'm going to be able to tell you, first of all, how you would go about staying there, and indeed if you can, and secondly, what the court's going to consider fair and reasonable in light of the fact that he's got this big pension, of which you're entitled to a share of that, and the fact that he's got...
Want me to touch it.
Well, it doesn't really matter what he wants, does it? It's what the court considered to be fair and reasonable. So we worry less about what he wants, and we worry more about what you're entitled to. and the fact that he's on a bigger salary than you. So you definitely need a consultation with me. Because I can't really take that question any further without asking you questions.
No.
And obviously I can't ask you questions on here.
Oh no, that's fine. Thank you.
That's okay.
And the other thing is, he's reduced the child maintenance payments because he says he pays the mortgage and he's not living here. I pay the bills, which I always have done, and he pays the mortgage, and he's reduced it to like less than a third of what he's supposed to give me because he's paying the mortgage.
Okay.
And like, is that a thing? Is that what people do? Because it's a nightmare.
Well, the great thing is that he's paying the mortgage, so that's spousal maintenance.
Yeah.
He probably doesn't know that, but he's already paying you spousal maintenance. Does he still live there?
Okay.
Does he still live there?
No.
Good.
No.
So he, indirectly, he's thinking, well, I'm going to pay the mortgage and protect my credit rating. Brilliant. But what he's saying indirectly is that I know that she can't afford to live there without my financial help, and therefore I will pay the mortgage. So we see that as spousal maintenance. When it comes to child maintenance, again, difficult for me to answer because I don't know what his salary is. I don't know how many children there are, and therefore I don't know how much he should be paying. But what I do say to people, particularly where he's an employee, which he is, he's not self-employed, you need to give CMS a quick call, because you can say to them, look, this mortgage repayment is in light of the fact that it's spousal maintenance. And in addition to that, he needs to be paying me child maintenance. So have a chat with them. I mean, again, when you and I have a chat for your consultation, I can go through all of that with you. But look, they try it all, don't they? I mean, I'm not saying everyone does this, but
like, he's off the planet. He's off his rocker. Like £3.50 a day for my children, like 2 kids. £3.50 works out as
I know.
a day.
Yeah,
it's like,
I do find that when we have a controlling ex on the other side, it can get difficult because, the world has to go according to their rules and not the family law rules. But we'll look.
I think if they're in that world of law, they think they know, don't they?
Absolutely.
They want.
Absolutely. You wouldn't be the first client where we've got a police officer on the other side, and every one of them is particularly difficult for that reason.
So that's the other, quickly, I know there's other people waiting. But,
that's okay.
So I've engaged with a mediator, and I've been doing it for 3 weeks. Like, I've been in contact with this mediator and want to try that way. So he's now not responding, and he's refusing to engage with the mediator.
That's okay. Then you're going to ask the mediator for the MyAMS form. And that's the form that we need to make a court application. And a lot of times that's where I just say, let's go there. It is pointless if they're not going to mediate and they're not going to negotiate because they have to have it all their way. Let's just get to court, because the minute we get to court, we have a finish line. A financial application is going to generate no more than 3 hearings. That's it. If you guys can't decide or agree at hearing number 1 and number 2, judge will decide at hearing number 3. So, if he's not willing to mediate, there's probably every chance he's not going to negotiate with me. So let's just make our court application. And it's better for everyone, because then we get to that finish line that bit quicker,
Do I have to pay for that? What do I have to pay for this court application thing?
Yeah, well, again, that depends. So there'll be a court fee. It's just around the £300 mark. The court fees went up recently, and I still haven't mastered them all. But a financial application, which is our Form A, is about £300. So that's just a one-off court fee. You won't pay anything in addition to that, unless you decide to have legal representation. And then, of course, I mean, if you have a consultation with me, I'll go through those costs with you. But you've got 2 options. You can either do it yourself, or you can have, legal representation. Or sometimes I have like hybrid clients where I'm doing a little bit and they're doing a little bit. Do you know what I mean? We can accommodate.
What do you mean DIY? Like, what bit? I don't get what you mean.
Well, filling out the form, send it to court.
Oh, fill out the form. Is that what you mean? Do it myself, fill out the form?
Yeah. And everything else. Representing yourself at court, doing it all. I mean, there's you can do it all yourself. So you don't have to have a solicitor, is what I mean.
Okay, I think I'd feel a bit worried about doing it myself against somebody that's in court a lot.
All right, that's fine. That's fine.
Obviously it's different type of thing, like law, but I would, Do you actually have to go in the court and stand up and like say, you know, like in court?
Yeah, you do. But
No.
but
He probably breathes that, and I'd be like pooing my pants. I'll take that.
family court isn't like what we see on the TV, though. They are a lot smaller and they're a lot more informal. But yeah, you do have to go into court. Yeah, absolutely.
Okay. What should I do? Email you?
Yes, you can either email me directly and I'll get round to answering those later on today, or you can just give the office a call. If you want to just give the office a call, that's fine as well. All right, whichever you want to do. All right.
Thank you so much.
No problem. I'll speak to you soon.
Thank you.
Bye.
Bye.
Let me come to you. Let's take you off mute. Hello, how are you?
I'm well, thank you. How are you?
Good. I'm good, thank you. Have you got a question for me?
Yeah, I've just got all the court fees up for you as well, if you want me to tell you them quickly.
Oh,
so you
yes,
can tell.
please. If you can read them out, that'd be great. Thanks, Captain.
So for a divorce, it's 612.
Okay.
For a financial application, it's 313.
Thank you. 300.
A consent order is £60.
Yes.
And the child arrangement application is 232.
232. I think that stayed the same, but the financial order's gone up 313. That's definitely gone up from 275. And the court fee's gone up a little bit, because that used to be 595, I think, and it's now up to 612. It's expensive, isn't it? It's expensive. All I would add on the back of that, what I would say is that if you are on a low income or in receipt of benefits, consider the EX160. Because if you fill out that form and send it into court, you may get fee remission, which means that you don't have to pay the court fee. Or sometimes court gives you a partial fee remission. So they'll say, okay, in your case, just pay £200. So if you are struggling to pay your court fee, it's well worth doing the EX160 first.
And then a quick question I've got for you, Tracy, is
Yeah.
can my ex-husband just walk into the house when I go out and take whatever he likes, saying it's all his? This is also causing stress to the children, who are now frightened he will just walk in. The house is in both of our names still.
Does he live there?
No.
No. And I wonder how long he's been gone for. Look, the answer to the question is no. He can't do that. I mean, if he's moved out and he's living somewhere else, regardless of the fact that the house is in his name, he should really afford her the courtesy of letting her know that he's coming round. The reason I asked how long has he been gone for is that, as a rule of thumb, if he's been gone, 2 or 3 months, then we can be fairly confident that he's got a fixed address somewhere else. And then I would suggest that she change the locks. And even though the property is half his, it doesn't matter. He lives somewhere else now. By the mere fact that she changes the locks, we're not changing his legal entitlement to that property. He's still a legal owner of it. But it just forces him to knock the door, which is good manners, if nothing else.
Hello, thank you. A really quick one. I had an unsuccessful relocation request in the UK, and I'm just wondering if you have any advice or if there's any general precedent for when a repeat application is successful going forward, and what I should bear in mind if I do consider going back to court.
So this was your initial application to relocate, was it?
Yes, it was, yeah.
And I don't want any details, but was the application to go overseas?
No, it was within the UK.
Within the UK. And how long ago was the final decision handed down by judge?
Oh, it was with months, so this year.
Oh, this year. Okay. So the first thing I would say is court's probably not going to welcome another application so soon. It doesn't really like decisions being questioned within at least a couple of years of one being made, just because, well, for lots of reasons, but a couple of reasons that I point out will be it's already spent time deciding this case. So unless you have had an exceptional change in circumstances, you're probably not going to succeed. That's the first thing. Now, you may have exceptional circumstances. Now, the other reason, and this is where it's worth taking advice, is what can we learn from what was handed down? Was all the evidence considered? Did you put your best foot forward? Was everything covered? Was anything missed? Do you think that the decision that was made was fair based on the evidence before the court? So if I were to speak to you, I'd be sort of asking you all these questions and really getting an understanding of how the first decision was made. And it might be that, you know, the answer is still no, don't go back to court just yet. You're not going to win. Leave it a couple of years. Does that help? Probably not.
Yeah, it does really help. And thank you for not asking me specifics. I probably would want to make an appointment with you or something to discuss that in a bit more detail.
Course.
Yeah, it's helpful to know that it's not a never a no, it's just a likely wait a bit.
Yes, absolutely. Unless, as I say, unless there's been some exceptional change in circumstance, but we can discuss that during an appointment whenever you're ready. All right?
Thanks so much.
Lovely.
Appreciate the quick advice.
No problem. Bye. Jenny, let me come to you. Hello.
Hello. So I just wanted to ask a really quick question regarding submitting your Form A to the court, which I did 2 weeks ago tomorrow, and I've not heard anything back. I've had no confirmation it's been submitted. I've not been asked for payment.
Yes.
Do you have any idea about timescales that they'd usually process it, please?
So how did you submit it, first of all, post or email?
I did email.
Great. And which court did you email it to? Just roughly.
Plymouth.
Plymouth. Okay, so not particularly busy. If you were going to say London or Birmingham, there is a bit of a backlog at the moment. I would give them a call, Jenny. You know, look, be prepared to be on hold. Most of my team are always on hold to the court for a good hour, sometimes an hour and a half. But give them a call. It might be that it hasn't been received, and they, while you're on the phone, they may give you another email address to use. Because typically, when we send in a Form A, within a day or two, we're getting asked for payment. So the fact that you've let it go 2 weeks, or they've let it go 2 weeks, tells me that there might be a bit of a red flag here. So give them a ring.
Yeah. Finding the phone number I've found challenging. I've gone through the gov.uk website, and it takes you through to like a generic phone line.
Okay, let me see if I can't help. Hang on 1 second.
Thank you.
Plymouth, where are you? Plymouth Family Court. Let me see if I can find something here. So try this number, Jenny, and it may be the one you've already got. Have you got a pen?
Yes.
So 01752 677
677
400.
You're an absolute star. I got
No
it was
problem.
a generic kind of 0300 number, so that is automatically hopefully helpful.
Yeah.
Thank you so much.
No problem. Good luck. Thanks, Jenny.
Thank you.
Bye.
Bye.
Captain, your mic's off again.
Sorry.
Hello.
I'm just going through loads of DMs I've been sent.
That's fine.
A lot of people are getting confused lately between decree nisi, decree absolute, conditional order, and final order.
Yes. Absolutely.
Could you just explain all of that?
100%. So up until April 2022, the sort of orders in the divorce were your conditional order. No, they weren't. They were your decree nisi and then your decree absolute. After April 2022, we had some different titles, and the decree nisi is now your conditional order, and the decree absolute is your final order. There are still some people on the old system where they've started the divorce pre-April 2022, and for whatever reason, they're not quite at the end stage yet. Sometimes people just leave it, let it lapse. Other people have gone to court to sort out their finances. So we do still have some of the older applications washing through, but decree nisi goes hand in hand with decree absolute, and your conditional order goes hand in hand with your final order.
Can you contest getting divorced, Tracy?
No, not on the new system you can't, because we aren't blaming anybody anymore. So you can't sort of say back in the olden days, we'd say, well, we didn't do that. You know, we didn't commit the adultery or whatever it might be. So, you know, you couldn't ever stop it. You could really slow it down though. But now it's harder to even slow it down, because now it's just based on the fact that the marriage is irretrievably broken down. That's it. You don't have to show the reason how it's irretrievably broken down. It just has. And the court respect your decision. So long as you're married for a year, then the court will grant you your divorce.
Fair enough. Makes it so much easier for people, doesn't it? And
it does.
we're living longer.
Yeah, we are living longer. I mean, the counter argument to that, of course, is that there was some groups that were up in arms when the new system came in, because they believed that it weakened the sanctity of marriage. Because it was easier to get divorced, and that lots of people were now just rushing into marriage because actually divorce was so much easier. It's not quicker, though. You do have to wait a year before you can get divorced, and the divorce process is still taking 6 months. And the reason for that is that, you know, we don't want people getting divorced within a couple of days, because that would make it very... might make marriage more attractive, because you think, well, if it doesn't work out and it takes me a couple of days to get divorced, it does still take you 6 months. And of course, the financial law around marriage is still very complicated. So, when you enter into marriage, we do see that in England and Wales as a contract. It's binding financially. So there's a lot to consider there.
Yeah, and this is just the law in England and Wales, isn't it? It's not
Yeah.
Northern Ireland or Scotland. They've got very different laws.
Absolutely. So Northern Ireland, even though Northern Ireland and Scotland part of the UK, the solicitors, if ever I get a query from Scotland, I will always say you're going to have to speak to a Scottish solicitor. Same with Northern Ireland. We can't give you any advice if you're outside of England and Wales.